Well, Mike said a lot of what I was going to say in introducing myself, but as you heard, one thing you might have picked up from that introduction is that my background has been as a privacy and security officer, doing compliance leadership throughout my career, rather than so much as an academic, though I've been in contact with a lot of academics down through the years. In large part dealing with making sure they can get the data they need to do their projects and dealing with a variety of questions about that. So this is all to say, I'm not an academic, so this is really my first foray into an academic lecture setting in quite some time. What I'm going to go over tonight is HIPAA, which is, since Mike queued me up for it, we say it elsewhere in the presentation, the Health Insurance Portability and Accountability Act of 1996, which is, as we're going to find out, the law that in the United States regulates access to health data. I will take questions during the presentation if you have any, and feel free to follow up with me afterwards. I leave my email at the end of this. So why would we care about the protection of health data in this context? Well, if you want access to health data, you need to know what to ask for depending on what you need. And we'll get into this further, but there are limitations. If you're considering bringing HIPAA regulated data, which we call PHI, we'll get to that too, into your organization, you need to know what you're getting yourself in for. If you're getting it in a non-regulated form because it's de-identified, you need to understand what you actually have. And you're more likely to be able to obtain access to health data because it's heavily regulated if you understand the rules around it and thus can have a knowledgeable conversation with the people who are the gatekeepers for it. PHI, data regulated by HIPAA, is different from other types of data. There are regulatory penalties associated with misuse of it. There's the constant risk of audits. If you have it, you're open to audits. There are very detailed requirements for how you need to protect the data, more so, for example, than for GDPR. It's a bit more directive than that. It's similar to the FISMA moderate level if you've had experience with it. There are special reporting requirements in the event of an incident relating to the data. And if you're going to get into de-identifying it, the rules are very specific. So your normal techniques will only get you so far. So let's take a step back, though. What is HIPAA? As I said, the Health Insurance Portability and Accountability Act of 1996. That doesn't say anything about privacy or security in the name, but the history is that's actually a law about being able to maintain insurance coverage when you change jobs. And to save money on that, it was decided that the US would expand the use of electronic claim processing in order to save cost. For those of you who are from outside the US, I'm going to explain this law. I'm not going to explain our health system. I think in many ways it's incomprehensible, really. But they added electronic claim processing in order to save cost on continuity of care, which then had a knock-on need to worry about protecting electronic health information. And as a result, the privacy and security rules got added to HIPAA, this bill about insurance coverage. And that's what drives healthcare regulation of data in the US. So HIPAA sets a floor for the protection of individual level health data in the United States. Individual states can choose to regulate it more, but not less, right? You can be stricter, you can give patients more rights, but you can't ever go below the floor HIPAA sets. And if you follow US privacy law enough to know that there's currently a broad-ranging privacy bill being discussed in Congress, it exempts data that's covered by HIPAA, so it's not going to change any of this. It scopes it out. So HIPAA regulates the use and disclosure of a category of information called protected health information, which we'll get to. There's really no way to explain this without hitting terms before we define them. It's circular. By two categories of organizations, covered entities, which is entities engaged in the provision of healthcare in some fashion, specifically health plans, healthcare providers, and clearinghouses, and a couple other niche organizations too, and business associates, which are organizations that covered entities provide PHI to do work for them with it, right? Those organizations are directly regulated by HIPAA. Chances are your organization won't be, but you can have the same rules basically placed on you by contract to some extent. It sets standards for the protection of that data, both from a privacy and a security perspective, gives individuals some rights to control what happens with their information, requires reporting of incidents, and sets some pretty significant penalties if you don't follow those rules. So it's got a sting to it. A quick note for non-US folks, rather. In the US, privacy law is sectoral, right? Europe has the GDPR, South Korea has a privacy law, Australia has a privacy law, Brazil has a privacy law. They're not sectoral. They cover everything with some carve-outs, I expect. Here in the US, we don't regulate privacy unless something bad happens and gets enough publicity that we decide we're going to fix it in that sector. When we do, we write a law for that sector, right? The financial sector's got regulations. Libraries have regulations. Video rental stores have regulations, all because a Supreme Court justice candidate named Robert Bork had his video rental records dragged out in the confirmation hearings, and people decided that was a problem, so they passed regulations. By the way, he rented really boring stuff unless you like Lifetime movies and historical reenactments. And finally, healthcare. What happened bad in healthcare? A lot of stuff, as you might imagine. But it included and in the US, right, employers often pay for employees' insurance. Frequently, that's how they get it. There was a railroad company, which was a self-funded insurer, meaning they had a pot of money they used to pay employees' health claims. They decided that what they were going to do was identify employees within their pool who had a 50% chance of carrying the genes for a very bad genetic disorder. And they would then fire those people to keep them out of the insurance pool. So they did genetic testing of employees, used the results, and took inappropriate labor actions. Some other stuff happened too, but that was really notorious. It may change. As I mentioned, there is a broad-based privacy law currently being discussed in Congress. Not sure. We're closer than we ever have been, but I'm not willing to predict which way it's going to work. But as I said, in Europe and a lot of other countries, it's different. In the case of Europe, for historical reasons, because they saw what the Nazis did with large identifiable data sets, which is why they call things like labor union membership sensitive. And then other countries had the GDPR to base their laws on and so forth. They're not all very closely based on it. Some are more stringent, but they had the inspiration out there. So who knows? Anyway, this is how it works in the US for now. So what is PHI? It stands for Protected Health Information. And it is data that meets these three criteria, right? First, it has some health information about an identifiable person. That can be anything from a condition that they have to where they get health care or who the insurance company is that pays for their health care. So it can be very seemingly innocuous. Has to have more than one or more identifiers that link that individual level health information to one or more specific people. And that can be anything from a name, which is obviously an identifier that links, right? Or a social security number, to the date on which a particular service happened. So it goes from, yeah, these clearly identify a person to, wow, these only identify a person if you have access to other data sets to link to it, which is an important point because it means they were thinking about that when they wrote it. And finally, the information has to have passed through the hands of a covered entity, a provider, payer, or clearinghouse. We'll talk more about all of these points. So identifiers that can make something PHI, remember, you got health information and it came through the hands of a covered entity. Now you got to worry about what identifiers are present, can be either direct or indirect. None of these should really surprise anyone, though I'll call your attention to the fact that way down at the bottom, there's a catch-all, a wild card, if you will. Any other unique identifier that you know specifically identifies people. In a situation that I dealt with at a previous employer, that unique identifier was job title. The state whose retirement system we were doing work with, they didn't think job titles were identifiable because they were thinking of things like senior system administrator. And it hadn't occurred to them that their governor was part of that database, right? How many governors do you guys have out there at a time? Identifier. And indirect identifiers, address, dates of events related to the care of the individual. These are all identifiers under HIPAA, right? There can be some flexibility. You can throttle the granularity of the indirect ones, but they're all considered identifiers, and that's not always the case in social science data. I've found with the indirect ones. I think everybody would agree the directs are identifiers. So some examples of data in the real world that is PHI or maybe PHI, somebody's medical record, a list of patients at a hospital with no other information. Remember, you don't have to know what they're in for. You have to know that they got treated at that hospital. The fact that somebody has, this is a big insurance carrier in Michigan that the university has as their insurance, a list of appointments with dates, but no direct identifiers. Remember, dates are identifiers. You can lift a list of social security numbers out of a PHI data set. And even if there's no other information attached, that's considered PHI because it started as PHI, and we'll come back to that. Obviously, a clinical test result for an individual would be PHI. Why would you be looking at this stuff? Some of it you probably wouldn't. But if you want to do social determinants of health research, for example, you may need some of the health part of the equation to do that. Some data sets which look like PHI are not PHI. And a recurring theme in my career has been discovering data sets that actually aren't. Somebody reports to me, hey, this is PHI. We've got it out here. I think we've got a data breach. Maybe we do, maybe we don't, right? Because context is important. Data that's collected solely for research usually is not PHI. I mean, collected directly from the person, right? Not if it's collected out of medical records, it's probably PHI. But research specific tests or imaging, we have data sets like that at ICPSR. Not the first time I've seen one either. Surveys about health that aren't given under the aegis of a covered entity, those aren't. Data collected in an employment context generally is not. Evidence for why you need an ergonomic keyboard, workers' comp claims, that kind of thing, those are specifically excluded from the definition of PHI. Even work-based clinics, often they're not under HIPAA either. And data covered by FERPA, which is the regulation that protects student data in the United States, is explicitly excluded as well. So there are a lot of restrictions on what you can do with PHI. There are security and privacy measures required. There are strong restrictions on use and disclosure. You have to get an authorization from the individual, or you're doing it for treatment, payment, or healthcare operations, which is a set of complexity we're not going to go into tonight, or an exception applies. One of the exceptions that's out there, fortunately, is for research purposes with some restrictions. There is a need to know rule, meaning you don't get access to PHI unless you have a work-based need to have it, and a minimum necessary rule, which means you can only have the minimum amount of PHI you need. It should be no more identifiable than it needs to be in order to serve the purpose. Anybody who's worked with GDPR will recognize there are similar principles at work there, right? And some obligations get passed with the data, obligations to protect it. So I won't do a deep dive on this. I want to reassure you, I don't think this is the audience for it. But from a technical security perspective, the HIPAA security rule requires a large number of safeguards to be present. And if you're not an organization that routinely protects data like this, you seriously have to step up your game to get here. ICPSR has multiple projects that are under a federal standard called FISMA at the moderate level. So when we needed to bring PHI in, we were already pretty close, but you have to formalize a lot of things. Remember, this is administrative here. None of these are technical, right? You have to have a formal security management process with regular reviews. You have to designate a security officer and a privacy officer. You have to screen your workforce. You have to have a lot of stuff around how you manage access to the data. You have to do training on a regular basis. You have to have incident response procedures, contingency planning. You have to periodically go and make sure you're doing this stuff. And there are a bunch of contracts with required language that you need to put in place around the movement of this data. There are also physical safeguards. Your normal university space where people freely walk in and out is not going to fly if you're dealing with PHI there, unless you find a way to isolate it such that that doesn't matter. Controls on facility access, that means locks, cards, the ability to know who's in it, workstation use and security, and then inventory controls on devices and media. Again, this is a heavy lift for organizations that don't normally see it. And finally, we get to the technical safeguards around access control, audit controls. You have to retain certain types of data for 6 years, for example, authenticating people, and transmission security, which is not quite synonymous with encryption because there are multiple ways you can meet that, but it's usually encryption, right? A dedicated lease line or something maybe, but broadly with HIPAA, you want to encrypt and you want to do it well. Overall, these measures are fairly similar. I mean, they're inspired by the NIST 800-53 standard. You know, they've kind of grown up together and they're roughly equivalent to FISMA moderate. They're expected to be flexible and scalable. In other words, a small company with 15 people isn't expected to maintain the same measures in place that we did when we were part of IBM Watson Health, which is a 350,000 person company with, they say, huge resources, but we didn't always see it where we were. It's not a light task to do this. And you do have to be ready to be audited, because as soon as you're receiving PHI, that's potentially something that could happen. Probably won't unless certain things occur. Now, the HIPAA privacy rule goes into even more detail than the security rule, and I'm not going to, because a lot of it is only relevant if you're in the business of healthcare. If you're a healthcare provider, you have to do things like give a notice of privacy practices. Anyone here who's US based has gotten one of those at some point, and stuff like that. So we're not going to do it. I'm just going to hit the high points. Use and disclosure of PHI are restricted. You can only use it. Oh, sorry. Use means something the organization that holds the PHI wants to do with it. Disclosure means giving it to another organization. Okay. That's a key point. Just because you can have PHI doesn't mean you can do what you want with it, right? Both the having it and the purpose you want to use it for have to be permissible. You can only disclose it under certain circumstances or to the individual or with an authorization they give you. We talked about minimum necessary and need to know. I apologize for the repetition on that bullet. But one thing you can do is you can take PHI and you can remove identifiers from it. You can de-identify it so that these rules don't apply anymore. The risks of mishandling PHI are significant. Audits are not fun, and they're mostly incident driven, meaning the Department of Health and Human Services, who are the people who enforce it here, specifically the HHS Office of Civil Rights, will ordinarily leave you alone unless you have an incident that gets reported to them, at which point they will throw the auditors at you. Biggest thing people get nailed for, by the way, is back in that administrative part of the security rule. It's for not doing complete risk assessments that they document. Biggest thing a lot of people skip, risk assessments. So just so you know, that's a pitfall. You can be fined. Fines vary depending on how big the incident was, how good you were, right, with respect to it. The biggest one so far is Anthem paying $16 million. Anthem had a massive hack back in about 2016, 2017, involving millions and millions of patient records. And it was probably an advanced persistent threat by another government because they do a lot of US government personnel stuff. They paid $16 million. $1 million, $2 million fines are not uncommon. There's the potential for criminal prosecution, prison sentences up to 10 years. This is for deliberate acts. Do people do deliberate bad acts with HIPAA? They do. Sometimes they remove data to use for commercial gain. Sometimes they look other people up to blackmail them, or because they don't like a coworker, that kind of thing. And it happens. The HHS agency maintains a website that we call the Wall of Shame. That's Health and Human Services, by the way, where they list different incidents where they've issued fines. So there's publicity. Direct costs of paying to fix a security incident, as you probably read elsewhere, can be high. You get bad publicity and people stop trusting you. So it's risky to have PHI in your environment. So there are multiple options then if you want to use health data for research. The first is get PHI. Fully identifiable data, you're probably not going to get it for research. We'll talk more about that. One situation where you might get it is that someone might provide to you, assuming that you can prove you have the correct security and privacy measures in place, so you can create a de-identified data set out of it, either for them or for other uses. So can happen. Second option is what's called a limited data set, still PHI. Some identifiers have been removed to make it safer. And it's the default minimum necessary. If you want to do research, you have to prove you need something richer than that if you do. De-identified data is not PHI anymore, because some identifiers, maybe a lot of identifiers, have been removed. While it then isn't regulated by HIPAA, they often carry contractual restrictions. And finally, aggregated data. If you use data that's not individual level, it can't be individually identifiable health information, thus it can't be PHI. So PHI, the only way you get to use fully identifiable PHI for research is one of these. First, you can get authorization from the patients involved. It's like a consent. It has specific provisions that have to be in it to be a valid HIPAA authorization. It's plausible. It's not plausible if you want to do a large-scale study or if you're looking at historical data, probably, but it's doable. You can get approval from an IRB, or I guess a determination that it's exempt, but we're talking about real PHI, so they won't. You can get approval from a group called a privacy board, which is similar to an IRB, but was created under HIPAA to do this. You can sometimes get the ability to look at PHI for review preparatory to research. This is most often going to come up in clinical research contexts, where you get to scan through patients and try to identify a pool of people who would be good research subjects for the project that you want to do. And then finally, you can do work on dead people's information. They still, under HIPAA currently, decedents have some privacy protections until they've been dead for 50 years. That may seem strange, but when you keep in mind that there are genetic diseases out there where if you know somebody's mother had it, then they have a 50% chance, that kind of thing. In other words, an individual's medical records can give you information about other people, and they've chosen to set the cutoff at 50 years. The medical historians I knew were delighted that they did that, because prior to that, there wasn't a rule about dead people. And again, the default minimum necessary for research is likely to be a limited data set. So let's go into that. A limited data set is still PHI, it's still regulated, but it allows more freedom of use. The allowable uses for it are research, hey, public health, or healthcare operations. Public health is very narrow. Healthcare operations is not research, so it's the research use. To create a limited data set, and we'll circle back around on this, all of the direct identifiers are removed and the granularity of the indirect ones is reduced. So for geocoding, you lose street address, but you can keep town, state, and 5-digit zip, not zip9. Zip9 can identify an individual house. The zip9 for my house where I'm sitting right now, there's nobody else in it, right? We're on some land south of Ann Arbor. With dates, you can keep the full date and time. You can use a limited data set under what's called a data use agreement. It's a very generic term, but under HIPAA, there are specific provisions associated with that. The usual stuff about not passing it on without passing terms and not linking to other data sets, that kind of thing. Next option, de-identified data. So there are two ways to de-identify PHI, of which most people have only ever heard of one if they have at all. If you don't follow one of these paths, it's still legally PHI. That's why if you take a list of social security numbers that you pull out of a PHI data set, even if there's no health information there, just a bunch of SSNs, it's still legally considered PHI because you didn't go through one of these de-identification processes to get there, okay? And neither process would allow you to keep social security numbers. I'm flagging here, again, the fact that HIPAA requires you to mess with the indirect identifiers. I'm doing that because it's not standard practice in our own curation unit, for example. So I assume elsewhere in social science, there isn't the focus on this that HIPAA has. It's one of the ways HIPAA is different. So the first method is called the safe harbor. You take out or reduce granularity on more so than for the limited data set. We'll get to this. All 18 of those direct identifiers, all 18 of the identifiers, plus anything else you know uniquely identifies someone in the set. It's easy to apply. The problem is it's analytically useless for a lot of purposes, because if the only element of year you're allowed to retain is, if the only element of date you're allowed to retain is year, which is the case in safe harbor, not only do you not know how far apart events happened within the same year, and a lot of researchers care about that, you don't even know what order they happened in if they were within the same year, right? And that's problematic. Geocoding can also be trouble because the only elements of geocoding that you're allowed to keep are state and 3-digit zip. The other method for de-identifying PHI is called either expert determination or the statistical method. An expert, and by the way, they don't define it, right? All of the ones I've met have been biostatisticians, and actually I should have given some citations, but you don't have to be. An expert reviews the data set, removes elements, and determines that the residual risk of identification, the number of population uniques in the set, is very small. What's very small? A few in 10,000, for example. So what you're starting with is something that looks like a limited data set. In other words, you keep dates, you keep city, state, and 5-digit zip, but then you work down from that, right? Do you need that much granularity on geocoding? Do you need full dates, or could you get by with month? And you jiggle it, and it can be a discussion. Some expert determination folks improve the de-identification by introducing random noise to the data, which is a method I'm sure everybody's heard of. Sometimes the term differential privacy is used for that, right? If you change the data around a little bit, that helps. But if you change the data around a little bit, some researchers hate that, depending on what they're trying to do. you'll get a written determination from them that this is statistically de-identified data. And they almost always put conditions on it that are very similar to the limited data set conditions. Can't link it with other data, that kind of thing. You may want different cuts of the data for different purposes, but you can't have the ability to combine them, right? If we reduce the granularity of geocoding to decrease the identifiability of the data on one data set, but keep full dates, and reduce the granularity of dates in the other one, that you can't combine them, should be obvious. Benefit, retains more granularity, so it's analytically useful. Disadvantage, they're always trade-offs. You need an expert to certify it. They're not cheap, right? And this can become a complicated process that takes time. Another option, aggregate the data. It's not one of the two de-identification methods per se, because the de-identification methods are about what you do with individual level data. Once you aggregate it, it's no longer individual level. Arguably, you meet safe harbor because it completely lacks individual identifiers. The interesting question here, first off, can you use aggregated data for your project? Depends. Population level projects, sure, right? Stuff where you're tracking individual interventions might be a little more complicated. How big the buckets have to be truly aggregate, HIPAA doesn't define that. In this group for the summer program, I assume a lot of you are very familiar with the bucket size question. And I'm not going to opine on it here. Different situations are different. I'll comment that the lowest I would ever consider going, and this is in health research where often you have a pretty small participant pool, is 11 on any bucket. And the reason for that is HHS does it for some of the data sets that they distribute. And if they come calling, I always wanted the ability to go, well, you can't say that's too small. You do it with your data set, right? So never had to, fortunately. And another option still, there are a number of organizations out there that license access to de-identified data sets, including my previous employers who licensed the market scan data set of health claims data. That was originally an organization called MedStat. I got hired in when they were Thomson Reuters Healthcare, sorry, the healthcare business of Thomson Reuters. We then became Proven Health Analytics, and then we got bought into IBM Watson Health. IBM has now spat the remnants of that organization back out to a private equity firm, much like TR did with us when we became Proven, and they're now called Meritive, but very large set of high quality health claims data. There are clinical data sets out there. You can get cuts, subsets that are specific to many variables. And these organizations will, for a fee, provide support in working with you on defining the data set as well. Benefit, it's definitely de-identified. It's on them if they screw up. And you can get consulting from people who help build the data set and know it well. Disadvantages, they might not have what you need on the shelf. They might not have all of the data elements you want because they may have excluded them or not have good filling on them. And it's expensive, right? It costs money. So still an option though. How do you link PHI to other data sets without getting direct identifiers? Sometimes you're not allowed to. Sometimes you can use probabilistic linking. Other times you may be able to work with a supplier to work through a third-party honest broker, where the honest broker sees identifiers but not data, and you get back data with no identifiers. But this is an awkward situation because you won't always have permission to do it. And at ICPSR, we often don't allow linkage to our social science data sets either. So it's a broader issue. So I wanted to revisit this to give a sort of a visual illustration of the situation with identifiers. So PHI is health information plus one or more of these identifiers. When you remove what you need to get to a limited data set or statistically de-identified data, it's going to look like this. And a statistically de-identified data set will not be this rich in identifiers. You're going to lose some of it, right? But remember, you're keeping all the health data, you've got the dates of service, you've got all that stuff, right? And it may be all you need, even if you can't, most of these are direct identifiers. You didn't need them, can't have them, right? So a limited data set or statistically de-identified looks like that. And then safe harbor looks like that. And you can see why people don't always like safe harbor. I left photographic image in here, not as a typo, but because photographic images of the face are problematic, or other images that are that identifiable, but most aren't. So there's some complexity around imaging. If you're dealing with imaging for some reason, and again, we have some imaging data sets at ICPSR, one thing you have to be careful of is that data sets of scanned images often have some of these things in them, like the patient's medical record number, sometimes the name in the metadata, right? Or sometimes printed right on the image itself. So you do have to look. Okay, I'm just going to end with some words on incident reporting in a high-risk situation, like when you're dealing with PHI. There are various ways you can get in trouble. You can have incidents. Not all incidents are breaches of the data. Some are. Someone gets access they shouldn't have. You leave PHI somewhere it shouldn't be. You thought something was de-identified and it's not. Maybe you didn't follow one of the HIPAA methods, or you lose data on some medium. Of these, I mean, I guess they're all bad, but HHS has absolutely had it with people losing disks and laptops, and they're not playing. Not all incidents are breaches, right? I do another version of this where I teach people how to handle data within their organization and how to report. And I kept these slides in from it because I think it's worth saying. HIPAA has very specific rules for how you decide where an incident where data may have gotten out is actually a breach. And it's important because if you actually have a breach, you have to tell the people who sent you the data, and they may make you tell the individuals who are in the data. Usually not, but they may make you pay for it. And the way they do it is they evaluate the likelihood that the data was compromised on a 4-factor test. And they say this is objective, but I've worked with this test multiple times. Every single one of these points is subjective, except maybe the third bullet, right? What's the nature of the data? Who got their hands on it? What that really means is if it's somebody who's already following the rules, they're part of your organization, those people are safer. Whether they actually got to look at it or not, and the extent to which you've addressed the risk. Some big exceptions which should drive your behavior. All right. Number one, data that's been de-identified isn't PHI. Whenever you can, work with de-identified data. If I leave you with nothing else, take that, please. Or if you have encrypted PHI to the FIPS 140-2 standard, it's another US federal standard, then if it gets out, it doesn't count as long as the password, the key didn't get out with it, right? So they consider data that's been encrypted to that standard safe enough that you don't have to report it as a breach if it gets out. And that's the end of the talk. I hope that at least some of that was useful for you folks. And if you want to follow up with me, I'm JM Saul at umich.edu. Thank you.
Thanks, Joe.
Yep.
We can take questions in written form in either the Q&A or the chat. Because we're in webinar format, your microphones have been muted. One thing that you might say something about, Joe, is in the context of the consortium itself, what kind of facilities does it have? What kind of procedures does it use to supply data to individuals or access the data for individuals where there is potentially PHI?
So I want to tackle the last thing you said first, because I think you teed it up for me. If you don't know whether you have PHI, you've already screwed up, right? We need to have absolute knowledge whether a certain data set has PHI in it. basically first rule of privacy and security is know what you have and where so that you can protect it. So if we have several different ways that we provide access to data. Sometimes we'll send it on an encrypted disk if you meet other security standards. We also have a physical data enclave where people can come and review certain records on site and not carry anything out with them. But my preferred method for anything that skates anywhere near the PHI line would be our virtual data enclave, which runs on a virtual desktop infrastructure environment. So you can look at the stuff, but you can't copy it off. You're working with a virtual machine with extremely limited function. And that's how we would do anything like PHI. We do have some PHI that it's there for a specific purpose. It's not being released of the full PHI variety, and it's on a separate system. But we also have some limited data sets in our possession, as well as some health data that would be a limited data set, except it didn't come from a covered entity, it's research data. And those would all be virtual data enclave kinds of things. So you would apply for it. You'd have to show that you have an IRB determination that allows you to, and that you're affiliated with an appropriate institution and you're PI capable. Your staff might not be, but the person applying has to be. We have a whole process for this. You'd execute a restricted data use agreement with us, which involves talking to the counsel's office at your university and an institutional rep signing off on it. So that's how we would do it. If you need to remove data results from that environment, we screen it before allowing data out, and then we provide it to you to keep it safe. Is that where you wanted that to go, Mike?
Yes, but also to make the point, Joe, that it's not as simple as getting a URL or a link to a particular site.
Right.
There's a process to obtain that information.
Right. And if we're going to provide it, there's a vetting process both on you and on the outbound data. Anyone else who's going to provide it, it's likely to be similar. If your organization wanted to bring PHI in, and you could get approval to do that, for example, to create de-identified data sets, you'd have to meet very stringent standards before the covered entity or BA controlling it would allow you to have the data. Incidentally, it isn't just the entity that has the data that you have to worry about. You have to worry about your own institution, because many universities are regulated by HIPAA over part of their scope if they have a medical center, for example. And even the ones that don't want to cross that line. So your biggest foe in trying to bring PHI into your organization is likely to be your own general counsel's office, if they're not already set up to handle it in a way that they can work with you. But again, de-identified data is not PHI. And while limited data sets there's a bit more freedom to move those around.
So let's say something more about the role of the IRB. The hypothetical sinister person is interested in getting information about somebody, let's say for investigative purposes. But the role of the IRB is to ascertain and approve of a legitimate research project. And that's right. One of the ways in which a line is drawn about who might have access.
Absolutely. The IRB's job is to protect human subjects, right? It goes, and remember when I said we only regulate sectorally and when it's necessary? I suspect everybody on the call understands why you have to regulate human subjects research. So I won't go there, but that's why the common rule exists. It's why IRBs exist. So their perspective is this legitimate research by the common rule definition? Are these people the right people to conduct it? If you have consent statements, are they appropriate? I'll come right back to that. And are subjects being appropriately protected? Remember, the IRB can approve consent statements, which include within them a HIPAA authorization. So one way you can get identifiable PHI to do a research project is by getting the individuals involved to sign off on it with an IRB approved consent. If you're going for a waiver of that authorization, then they're going to look very carefully at you. And going back to HIPAA, right, the minimum necessary principle for research, the default minimum necessary has been defined as a limited data set. So if you want to go beyond that, which is the only way you could really be nefarious with people with any confidence that it will work, you have to get that past an IRB. A limited data set, or even, I was trying to decide if I wanted to go down this path, but we have time, right?
Yes.
You would think that HIPAA safe harbor data is the safest data in terms of not being able to identify people because it's less rich. And because they call it safe harbor, legal term of art, by the way, you do this and you're okay is all it means. It's really not. And if you talk to people who work with de-identification of data, you'll quickly find out that they know this. And where it falls down is there could be population uniques that you're not aware are in that population that still show up in a safe harbor data set. For example, the octomom. There aren't that many people who had 8 childbirths in 1 year, right? She would be relatively easy to pick out from a data set. And if the data set supplier didn't know she was in there, they might provide that. A statistically de-identifying operation is more likely to catch that. Also, rare diseases. When medical coding went from ICD-9 to ICD-10, it got a lot more granular. ICD-10 literally has a code. I'm not going to quote it right, but it's something like injury due to turtle subsequent encounter. They've also got a code, spacecraft injury. Think about that one. Any spacecraft injury is going to generate media coverage. A turtle bite might not. They have aircraft injury codes. Aircraft crashes generate public records of coverage. At one point, there was one individual in the continental US diagnosed with Ebola, and many people knew where he was because that was in the newspapers as well. He was in a data set somewhere, right? So a safe harbor data set ain't necessarily all that safe, I guess is what I'm saying. Whereas a statistical one, when the expert does the expert determination, they do it taking into account what data they know is out there in the public eye. I don't do them by myself, but for the past 14 years, I've worked with people who do. And I understand it very well, and I've been part of the process. And they look for that kind of thing. You know, oh, these diagnosis codes, you need to eliminate them from your data set. Death dates also become problematic, but don't make me say much about that because it's been a while, and the death record is a very complicated topic because death creates a public record, obviously.
And I'm going to ask you to say something about consent, the difference, the meaning of consent from the perspective of an original data collector, PI, as opposed to an archive that is disseminating other people's data to researchers. The PI has a consent obligation in the collection of the original data.
Yeah.
But the archive data are beyond the level of consent ordinarily, especially if they're anonymized.
So if they're truly anonymized, and I'm going to assume basic GDPR, I shouldn't, if they're truly anonymized, which in the GDPR and many other places, but not all, means even the original owner of the data set couldn't identify people out of it, then I don't think there's a consent issue because it's not linkable to an individual by definition. That's not the case for a limited data set or some other categories of data. I think that the gatekeeper there is the IRB that decides whether to grant a waiver of consent, or decides to exempt the this use of the data from IRB determination, right? Well, I guess an exemption is an exempt determination. They don't feel they need to approve it because they don't feel the data puts human subjects at risk. So the short answer is the ethical gatekeeper is the IRB.
But if you are requesting a data set from an archive, there is no way to get consent for that researcher, right?
No, the initial researcher may have had consent, but for subsequent uses of the data set, it's all about an IRB or privacy board, right?
So consent is a relative concept in terms of the distance of the analyst from the point of original data collection.
Yeah, absolutely. Because they're disconnected. They don't have the ability to get those consents. And they wouldn't, and often it'll be something like a limited data set where they won't have enough information to get those consents, even if they wanted to, right? So again, we're heavily reliant on the IRB's role in saying whether they feel that's ethically appropriate.
Yeah, so I'll ask you a question about, kind of a hypothetical.
Yeah.
Because I'm involved in a research project that includes social media data and survey data, but we often talk about issues of the collection of Twitter data,
right,
from survey respondents who have consented to give their Twitter handle so that their tweets can be collected. And and I know that the ICPSR is going to get involved with the social media archive.
Yeah, I already have been in the planning stages.
Right. So we could de-identify in various ways an individual, but if the exact wording of a tweet is available, in principle, it would be possible to identify a person.
Absolutely. Look, free text entries, and obviously that's outside the HIPAA context, but it's 100%.
Right.
It's 100% true. You might even be able to identify someone by traffic analysis alone if their behavior was extreme, but certainly by searching for the payloads. That comes up in the HIPAA context because where you have free text like physicians' notes, it's extremely hard to be sure that's de-identified. One example that I was given years ago was a company was working on ways to automatically de-identify medical record data, clinical encounter data. And they hit a physician's free text where it says the underlying cause of the patient's back problems is her extreme height. And they gave her height. I don't remember what it was. And then says, she was the second tallest woman in the world in the Guinness Book of World Records in whatever the year was. And you aren't going to catch that with an automated system. And you run into the same thing on the social science side of the line, but without the kind of extreme HIPAA penalties and regulation associated with it, with free text survey data or questionnaires, or tell me about your undergrad experience, or tell me about tell me about how available food is in your neighborhood and how far you have to travel to get fresh vegetables, that kind of thing. Anything with free text presents serious de-identification challenges because you don't know where the data elements are that are dangerous, and you have no idea what they're going to put in there. So yeah, it's hard. Tweets are worse because, as you point out, they're searchable. The other trick with tweets is there's often correspondence with other people involved as well. So.
Oh, yes. figuring out a network.
Oh yeah. And people are the right people, or maybe the wrong people, are extremely sophisticated at teasing out networks from traffic analysis and context.
I mean, and this is, outside the purview of the normal business of the consortium. But when these data sets are made available to commercial companies to link with other data, the possibilities of triangulation on individuals increases rapidly.
They're huge. And when you consider not just the known data sets that are flying around out there, but the large semi-dark data sets held by data brokers who may have everything except a name, they can build up very detailed pictures of behavior. And in fact, I worked with an organization that protects websites from that kind of information leakage before I came to ICPSR. It would be a violation of conflict of interest for me to advertise them, but they finally came out with a product. So there are people working on the issue, but I can tell you from my time working with it that a lot is being collected by seemingly innocuous things like Google Analytics and so forth. In its proper context, it's not necessarily bad, but those data sets are potentially out there for abuse, or portions of them are, and it's something you have to take into account.
And in some cases for sale.
Frequently for sale, either legitimately or on the quote dark web, unquote.
Yeah.
I mean, I don't want to fear monger, right? The history of the internet has been fear mongering from day one. If anybody remembers the photo on the cover of Newsweek of the little kid staring shocked into a monitor and you see the blue glow. I was working with these issues then while I was in law school and at the University of Michigan, and it provoked some pretty extreme behavior by law enforcement and so forth, because there was a moral panic around it. I don't want to go there. I do think realistically, if you have a data set that's very dangerous to have linked to other things, if you're an organization like the consortium, if you're us, you have a moral an ethical responsibility, say, to make sure that you distribute that in a way that prevents linking, for example, through the VDE, unless it's been determined that it's safe or people have consented or whatever. But there's a lot out there.
So we still have a few minutes left. If members of the audience have questions that they want to raise with Joe, you can put your questions in the chat or in the Q&A. All of these points that you've been talking about this evening are prior to any kind of analysis or interrogation of the resulting data set that could lead to identification.
I touched on that.
Yeah.
In that when we provide data sets in the virtual data enclave, we do vet what comes out of there to make sure that it's not unacceptably dangerous. And I think that's responsible. And I guess I also touched on the other side of it too, right? You release a data set that's derived from HIPAA data and people turn out to be identifiable in it. The feds are coming.
Right.
You know, that's there's enforcement around that. That enforcement is real. I've been involved in multiple. I'm not going to give numbers or where, but I have. It's real. So yeah, you have to look at the output end of it too. And you have to vet what's going into a publication. And I think that's probably especially challenging in the social media context because of the ability to search text. But it's problematic in healthcare too. There are states that have released hospital-related data sets, and it's later turned out that you can link those with other publicly identifiable data sets and potentially identify people in that pool. There are techniques to avoid that, but that's probably more of a rabbit hole than we want to go down right now.
Well,
Suffice to say, they haven't always used those techniques.
right. I don't see any questions appearing in the chat or in the Q&A. Most of our audience members are graduate students or young researchers starting out in their careers.
Yep.
They probably aren't data generators yet, but they're data users. And so what you've been talking about in this very interesting presentation this evening is really issues of getting access to data that other people have collected, and the necessary legal safeguards that are required to protect confidentiality. But Joe has provided his contact information in the final slide, which you can see on your screen. But the slides will also be uploaded along with the video of the presentation. So you'll have a semi-permanent record of a way to get in contact with Joe.
Yeah.
I want to thank you very much for your presentation tonight. We'll let the audience plus other members of the ICPSR email list know when the recording is being made available on the YouTube channel. Thanks again, Joe.
Great. Thanks, Mike. Thanks, Kais and Kate, for making this an easy experience as well. And the rest of the summer program team, who I'm not remembering all the names of, but thank you for the opportunity. And please feel free to reach out to me if you want to talk about any of this. Take care.
Thank you.
Thanks.